Article 4, Section 1, Fall of Faith and Credit Clause by Stephen E. Sanders and Stephen Sanders. Common interpretation. Most of the original Constitution focuses on creating the federal government, defining its relationship to the states and the people at large. Article 4 addresses something different: the states' relations with each other, sometimes called horizontal federalism. In the first section, the Fall of Faith and Credit Clause requires every state, as a part of a single nation, to give a certain measure of respect to every other state's laws and institutions. The first part of the clause, largely borrowed from the Articles of Confederation, requires each state to pay attention to the other state's statutes, public records, and court decisions. The second sentence lets Congress decide how those materials can be proved in court and what effect they will have. The current implementing statute, 28 U.S.C. Clause 1738, declares that these materials should receive the same full faith and credit in each state that they have in the state from which they are taken. This broad statement of principle does not always translate well in specifics. States will take note of each other's public records, but the end always expect to give these records precisely the same effect that they have at home. A fishing license from one state doesn't give you the right to fish anywhere else. The clause and the federal implementing statute also have a relatively light impact on state statutory law. As the Supreme Court has recognized, when two states' laws are in conflict, it's impossible for both of them to give effect to each other's law at the same time. Alaska Packers Association versus Industrial Accident Commission, 1935, in situations where either state's law could plausibly apply, say, a car accident in Florida between two residents of New York, where the two states have different ideas about how to parcel out damages. The clause exerts relatively little force. Under the prevailing standard, in All State Insurance Corporation versus Hagel, 1981, and the Phillips Petroleum Corporation versus Schatz, 1985, depending on where the case is filed, either court can apply its own state's law to the disputes, so long as then the state has a significant contact or significant aggregation of contacts, creating state interests such that choice of its law is neither arbitrary nor fundamentally unfair. Once a court has made a decision, though, the clause has real teeth. As long as the state court has authority over the case and the parties, its judgments will conclusively determine the parties' rights in every other state, even if it might be wrong on the law, and if the judgment violates public policy in the state where it's enforced. One state judgment on the gambling debt can still be collected in another state where gambling is a crime, and the court establishing Fort Lauderdale versus Lum, 1908. In recent years, the most controversial application of the Full Faith and Credit Clause has involved family law. Each state has slightly different laws about marriage, and marriages themselves typically untreated as judgments, receiving nationwide effect until recently. Same-sex marriages formed in one state weren't always recognized elsewhere. Congress attempted to use its power under the clause to slow the recognition of same-sex marriages by passing the Defense of Marriage Act, 1 U.S.C. Clause 4, 28 U.S.C., I think that stands for U.S. Congress, Clause 1738C. But this was rendered obsolete by the Supreme Court decision Obergefell versus Hodges, 2015. Other marriages are still treated differently in different states which have conflicting rules about marriages by young people or between close relatives. Because divorces often take the form of court judgments, they usually do receive nationwide effect so long as the instant court has necessary authority over the parties. Congress has rarely used its power under the clause, but it has passed statutes clarifying which courts may issue orders on child custody. 28 U.S.C. Clause 7038A, and child support. 28 U.S.C. Clause 7038B, when a family is spread across multiple states. Matters of debates. Full faith and credit in court and in Congress by Stephen E. Sanchez. Article 4, Section 1 was supposed to do two things: to help states identify public documents from other states and to let Congress specify those documents' legal force. Over time, though, those purposes were slowly forgotten. Ignorant of the history, courts have relentlessly misinterpreted the clause in a way that diminishes Congress's powers and enlarges its own. In early America, a time before copy machines, when nothing moved faster than a horse, courts rarely knew which handwritten document was actually another state's statute, or which half illegible wax seal actually belonged to some county court many weeks travel away. To avoid conflict, Article 4 of the Articles of Confederation says that each state's documents should get full faith and credit elsewhere. This was a standard phrase about evidence. Business documents bearing a corporation seal might get a full faith credit when they were treated as authentic in court, without needing any witness to testify about how they were made. So the newly independent states were obliged to do, as James Wilson later said during the Convention for 1787, what now takes place among all independent nations to treat other states' documents as genuine when they were adequately proved. But each state had different rules about how to prove them, and what the documents should look like, for instance, which ones needed which seals or which had been signed by which officers. And if a document was genuine, courts disagreed on what legal force it had outside its home state's borders. So the committee in 1781 recommended that Congress make those rules, setting a uniform standard that every state document could meet, and declaring the legal effects. That is what the Constitution did. The first sentence of Article 4 excuse me, sorry. Where we were. Okay. Let me repeat the sentence. That's what the Constitution did. The first sentence of Article 4, that a full faith and credit shall be given, largely copied the Articles rule which James Madison saw in the Federalist number 42 as of little importance, of little importance under any interpretation which it will bear. It made states recognize each other's documents, now including legislative acts, without seeing how to authenticate them or what legal effect they have. Instead, the clause next sentence gives those powers to Congress. In 1790, Congress passed a statute setting out evidence rules and requiring that certain records and court judgments, but not the statutes, have such a faith and credit given to them in every court as the hand and the home. Acts of May 26, 1790, Chapter 11, 1 Statute 122. Courts disagreed about what this meant, and Congress eventually gave up trying to clarify it. Stephen E. Sanchez, For Faith and Credit in the Early Congress, 95. I think that's Virginia Law Review, 1201, 2009. As the Supreme Court read it, each state had to recognize other states' court judgments as conclusive. Mills versus Derry, 1830. But they could use different remedies to enforce them. See McElmoyle versus Cohen, 1839. And only if the state had the authority to decide the case in the first place, the Archie versus Kitchum, 1850. For 100 years, courts never says that it's a clause or the statute that made one state apply another's laws, until a confused decision in Chicago and Alton Railroad Corporation was Wiggins Ferry Corporation, 1887, suggested as such. C.W.E. Iredell, the classic role of faith and credit. Okay, I'm going to not read the reference, okay? From now on, actually. Okay, let's continue. Since then, the Supreme Court has treated the clause as an almost mystical source of national unity. And when states do disagree, as empowering this court to choose in each case between the competing public policies involved, Humes versus Federer, 1951, the court usually lets each state favor its own laws. In all states, Insurance Corporation versus Higgo, 1981, except when it doesn't, as in Franchise Tax Board of California versus Hyatt, 2016, creating plenty of confusion for those whose interests cross these lines. In other words, the discretion the founders made for Congress and are being taken up by the court. These kinds of problems are better ones for Congress to decide. Should a 14-year-old be able to elope in another state if they can't get married at home, whose law governs contract made over the internet, or major accidents with victims in many states? Everyone has something at stake in these questions. If we are going to change the answers, we should do it through elected representatives for whom everyone votes. That's what the For Faith and Credit clause said, and hopefully one day the courts will listen. Next perspective. For faith and credit, some lingering dilemmas by Stephen Sanders, The purpose of the Forfeit and Credit Clause, the Supreme Court said in All States Insurance Corporation versus Hagel, 1981, was to transform the several states from independent sovereignties into a single unified nation. The great Justice Robert Jackson, who made himself something of a scholar for the clause, argued that where there is a choice under the Forfeit and Credit Clause, the one should be made which best will meet the needs of an expanding national society, for a modern system for administering a more certain justice. Robert H. Jackson, Forfeit and Credit, the lawyer's clause for the Constitution. Today, Article 4, Section 1, is rarely the subject of a controversy or Supreme Court attention. It is well settled, and the final court judgments rendered in one state must be honored in every other state. There is no revolving public policy exception to the principle of mandatory recognition for judgment. Baker versus General Motors Corporation, 1998. This principle is consistent with the high premium that the law places on the finality of judgments, members together with the idea advanced by some jurists and scholars that the Forfeit and Credit Clause was originally intended foremost as command to state courts. Ordinary laws and statutes, however, are a different story. Because the United States is a highly mobile and interconnected society, scenarios often arise where one event, for example, a claim under an automobile insurance policy, could plausibly be governed by the law of more than one state. The Supreme Court has consistently held that as general, every state is entitled to make its own laws, and so a state is allowed to apply its own law in its own course as long as it had sufficient contacts with the matter being adjudicated. One state generally is not required to bow to the idea of other states on matters of public policy. This makes sense. Much regulation of our daily lives still takes place at the state level, and states are co-equal sovereigns, and the idea of states as the laboratories of policy innovation continue to have appeal. But what about state laws that not only express the state's public policy and regulate behaviors within this territory, but also confer important legal standards, such as marriage or parenthood? Both marriage and parenthood create well-established bundles of legal rights. If State A creates a marriage or a parent-child relationship, should State B be allowed not only to ignore standards, but also deny, even effectively terminate, the legal rights entailed by the standards? This question remains perhaps the most significant unresolved dilemma in the modern law of Forfeit and Credit. On the Supreme Court in Obergefell versus Hodges, 2015, held on the due process, the equal protection provisions of the Constitution's 14th Amendment require same-sex marriage to be legalized nationwide. Many states refuse to recognize same-sex marriages performed in other states, sometimes even going as far as to declare such marriages void or invalid. See Stephen Sanders' constitutional rights to keep your same-sex marriage. The conventional wisdom among scholars that the Forfeit and Credit Clause was no help to couples whose marriages were not recognized because marriage is simply another subject for ordinary state lawmaking, no different from things like workers' compensation, insurance regulation, or natural gas royalties, where under Supreme Court's precedent, each state gets to decide policy for itself. And then conventional wisdom can be questioned because it fails to account for the important vested personal rights that arise from marriage, especially rights over things like property, children, and inheritance rights whose purpose is to vindicate both the couple's and the society interests in stability, equality, and predictability in the marital relationship. See Stephen Sanders, is the fourth created clause still irrelevant to same-sex marriage towards reconsideration of the conventional wisdom. Moreover, the conventional wisdom seems difficult to reconcile with the deeply embedded American legal tradition of treating marriage as sui generis legal construct, a presumptively lifelong standards from which there can be no exist without the state's permission through divorce. The Supreme Court has long described marriage as the foundation of the family and of a society. Maynard versus Hill, 1888. Same-sex marriage was settled by a ruling under the 14th Amendment and Comedy. In interstate recognition, marriages have always been the rule rather than the exception, yet the fact remains that unless and until the Supreme Court says otherwise, the states continue to have no constitutional obligation under 14th grade to recognize other disfavored types of marriage, such as marriages between first cousins, with which they disagree. The federal circuits are split on another question of family law under 4/5 credit. To what extent and in what manner should one state be required to recognize adoption procured by a couple in another state? See Thomas M. Johnston, Half Faith and Credit of 5th Circuit upholds Louisiana's refusal to issue a revised birth certificate. Because adoptions are finalized by court judgments, one review holds that any adoption should be recognized by all the states for all purposes, even if it violates the public policy of the receiving states because, for example, it involves an unmarried couple. This is a better view given the importance of certainty and stability in the parent-child relationship. But the onliner decision from the 5th Circuit U.S. Court of Appeals in Adder v. Smith, 2011, held that Louisiana was not required to issue a new birth certificate recognizing two unmarried men as the parents of a Louisiana-born child whom they adopted in New York. The appeals court reasoned that the 4/5 and the credit command by state courts, but not non-judicial actors such as administrative officials who oversee the state's birth records. The U.S. Supreme Court declined to hear the parents' petition for review. And that's the end of this.